Okay, folks, this is Doug Pinkham with Pinkham & Associates, a dedicated family law firm in Orange County. I am now going to go over another form that is attached to a judgment. It might be attached to some other court orders for custody. It could be attached to a request for orders if you're asking for custody orders. Responsive declaration if the other parent filed a request for orders. Anyway, this again is an attachment form with regard to legal custody. Now keep in mind, it's going to be very clear when I go through the form, but legal custody again is the rights to make those serious decisions with regard to a child or children's lives, such as health, education, and welfare, the decisions with regard to those issues. All right, so I'm going to dive right into it. Oh, by the way, I know some of you see this form. That's great. If you do, that's fantastic. You can follow along line by line. If you cannot see the form right now, there's a link. Print this form out and follow along line by line. So just pause this video, print it out, get it ready, and follow along line by line. I'll help you go through this form to understand this form better. All right, starting at the top. As on all of these forms, the petitioner's name, respondent's name, and case number go at the top. All right, then you're going to want to mark the box which corresponds to that form which this form is going to be attached. So is it attached to the petition, the response, a request for order, responsive, declaration to request for orders, stipulation for judgment, stipulated order, findings in order after hearing, whatever it is. Find the box and mark the appropriate box. Okay. There's an important notice here, and I'm just going to read it out loud. It says right there at the top of the form, notice, in exercising joint legal custody, the parties may act alone as long as the action does not conflict with any orders about the physical custody of the children. Use this form only if you want to ask the court to make orders specifying when the consent of both parties is required to exercise legal control of the children and the consequences for failing to obtain mutual consent. There's also a place, and I'll let you know, there's also a place in this form. This form can also be used if you're going to have one person be in charge of any particular issue. And I'll give you an example. Let's say father is in the military and is, stationed in Afghanistan. Let's say, whatever. Let's say father, or let's say mom's in prison for check fraud. Who knows? But you still want to have joint legal custody with regard to a lot of issues. It may not make sense for somebody that is in either of those situations to have equal decision power over, say, schooling issues. Because what if there's a schooling issue that needs to be decided? What if a report card needs to be signed? What if a permission slip needs to be signed? What if a waiver for an inoculation needs to be signed, or something needs to be done? It needs to be signed in the next 3 days. How are you going to get that signed from somebody that's in Afghanistan, or somebody that's in prison, or somebody that, even if it's somebody that you don't get along with and you want the court to say, we can never make a decision on this. I want to have sole control over the decision making when it comes to schooling, or something to that effect. So you can do that in this form too. It's not just for maintaining or controlling when you both have control. All right, so let me go through the form. Under Section 1, the parties, and specify petitioner, respondent, will have joint legal custody of the parties. So you're probably going to mark petitioner and respondent there. Will have joint legal custody of the children. 2, generally speaking, when you want standard joint legal custody orders for all of the issues, you're going to mark most of these boxes, most or probably all of these boxes in this section, and further down too. I'll go through it to explain, but if you want one person to have specific control over a couple of issues, you're going to want to be very specific on that. But anyway, so let's say in exercising joint custody, the parties will share the responsibility and discussion in good faith, and discuss in good faith matters concerning the health, education, and welfare of the children, the parties must discuss and consent in making decisions on the following matters: enrollment in or leaving a particular private or public school or daycare center, beginning or ending psychiatric, psychological, or other mental health counseling or therapy, participation in extracurricular activities, selection of a doctor, dentist, or other healthcare professional, except in emergency situations. Now, even if you have joint custody, even if you mark this and you guys have joint custody and need to make both of you need to make decisions equally on health care providers, if a child has a health emergency, you are allowed to act right now to bring that child to a hospital or a doctor. Don't question that at all. You have a duty to take care of your child. You just need to let the other parent know immediately. So as soon as you possibly can, get the kid to the emergency room, get that medical treatment going, and as soon as the child's being taken care of and you have a moment, call the other parent and let them know what's going on. E is participation in particular religious activities or institutions. So if you're going to change a child's religion, or stop taking them to church, any of that kind of stuff, that's a joint legal custody issue normally. Any out of state or out of country travel, if you're not concerned about that, if both of you have family outside of state and you don't want to have to constantly be letting the other one know, and there's not really a concern that they're going to steal the child out of the state or something like that, or you don't think that they're going to, take the child and take off to Florida during your time, then you don't really need to mark that one. If you think that there's a concern, or you want a rule that you both have to agree on any out-of-state or out-of-country travel, then mark that box. If there's some other issue, you can mark it under other and then specify in that next box. Section 3, if a party does not obtain consent of the other party for those items listed in number 2 which are granted as court orders, he or she may be subject to civil or criminal penalties. Notice there's not a box there. That's California law. It's true. If there's joint legal custody and you are not consulting the other party to get their opinion on and their decision making equally on these issues, you can get in trouble civilly or criminally. So be careful. B says the court may change the legal or physical custody of the minor children as a result of not exercising joint legal custody. So if you are constantly making unilateral decisions and you don't care what the other party says or does or what they think or how they feel about this stuff, and you're making unilateral decisions, I'm here to tell you, I have had judges take physical custody away from, change physical custody, because the one parent is not working with the other parent so pervasively and so seriously that it harms the kids. So don't fool yourself. Judges will do that. So, work together. Co-parent. Other consequences. So if there's some other consequences that you guys agree on or that the judge ordered, you can mark that under C and then specify to the right. Okay, so special decision-making, designation or access to children's records. Okay, so this section is where one of you may have special decision-making provisions. So let me read it. And if this is the case, mark number 4, and it says the petitioner, or you can mark the respondent, will be responsible for making decisions regarding the following issues, and then be very specific in there. So let me give you an example. If it was the schooling issues like I discussed earlier, and let's say dad's in the military and he's stationed in Afghanistan, and it really doesn't make sense for him to be involved in the day-to-day schooling activities and that kind of thing. If you guys agree to it, or if the court orders it, don't mark the school box up in number 2, and then you can mark, say, petitioner, and then put all issues with regard to schooling and education or something to that effect in this box. Or it could be healthcare or whatever it might be. If one parent is going to have specific control over one particular health, education, or welfare issue, this is where you put it, number 4. B says, both the custodial and non-custodial parent have the right to access records and information about the minor children, including medical, dental, school records, consult with professionals who are providing services to the children. This is Family Code Section 3025. It's California, it's standard California law. That's why there's no box to mark there. It's just kind of just warning you. Everybody, you know, has the right to do that. All right, 5. And by the way, keep in mind that's custodial and non-custodial parents. If you're the parent of this child, you have a right to that information. Number 5, health care notifications. A says each party must notify the other party an address of each healthcare practitioner who examines or treats the children. Such notification must be made within blank number of days treatment or examination. This is not talking about an emergency. If there's an emergency, well, the emergency comes up in the next paragraph. But anyway, this is like a new doctor, or, you know, let's say you've got, you know, some, you know, HMO or something, you got Kaiser or something like that, and you go to the doctor and all of a sudden you've got a new provider for the child. You need to notify the other parent of that new doctor's name and information within, and then you can put in here 2 days, 3 days. I can't imagine it should be more than 2 or 3 days. Because, I mean, that's a serious thing. You want the other parent to know what's going on. B, and this is more of the emergency stuff. B says each party is authorized to take any and all actions necessary to protect the health and welfare of the children, including but not limited to consent to emergency surgical procedures or treatment. The party authorizing such emergency treatment must notify the other parent as soon as possible of the emergency situation and of all procedures or treatment administered to the children. So that's what I was talking about earlier. You absolutely have a duty to take care of your kids if there's an emergency. Take them in, get them fixed up, get them healthy. Do what you need to do to protect your kids, but notify the other parent immediately as soon as you can. C says the parties are required to administer any prescribed medication for the children. So there are some parents who do not believe in administering medications of any kind to children. Well, as you are likely aware, there are doctors who say some medications are absolutely mandatory, necessary. If that's the case, then you might need to get a court order that says that this other parent who's reluctant to give, medications to the child must give the medications to the child that are prescribed by a doctor. 6, school notifications. This is just a standard. But I'll give you an example. So each party will be designated as a person the children's school will contact in the event of an emergency. This is the emergency card. Both parents should absolutely be listed on the emergency card. I've had cases where, dad will list dad and stepmom on the emergency card, not even name mom. The school doesn't even know there's a mom, doesn't even know that the stepmom is the stepmom. They just presume it's mom because dad didn't specify. That's a huge no-no. Mom and dad's name both need to be on the emergency card. And if you mark this, then it becomes a court order too. 7, name. The parties will not change the name of the child. This is really straightforward. You won't change the name on any records, any school records, medical records, or certainly with, the state of California. You want to mark that one, just safe. It doesn't happen very often that somebody would do that, but go ahead and mark it. And then 8 is anything other. So if there's some other issue with regard to legal custody that you agreed to or that the judge ordered, put it in there, be very specific so that it is enforceable. If it's not specific and we're going, I'm not sure what that really means, it won't be enforceable. All right, folks, that is the joint legal custody attachment. It is attached to a judgment or a court order or a request for orders or a responsive declaration. It's always attached to some other form. You're never going to file this form on its own. That's it for this form. I hope this video was helpful. And again, my name was Doug Pinkham with Pinkham & Associates. Thank you very much.